Recording in progress.
I'm sorry, say that again?
Magistrate Williams, can you just tell me your name, sir, just to make sure you're here at the right case?
Dan Williams.
Okay, thank you. Just a moment. This is case 2019 DR 9764, and this is motion to enforce a support order. That's what's set by Department of Revenue. It's motion filed by Department of Revenue. Again, Mr. Williams, just state your name for the record, please.
Dan Williams.
Thank you. And ma'am, state your name for the record.
Deborah Johnson.
All right, thank you. And just be sure that you have the microphone pointed in your direction, make sure everything's picked up. Thank you. Ms. Johnston, you filled out the email designation, John and Deb 12345@AOL.com.
Yes.
Okay, so your email will be designated with the clerk for purposes of e-service. See a number of motions that have been filed by Mr. Williams. You can make your appearance.
Nicole Jackson on behalf of the Department of Revenue.
All right, thank you. I see a number of motions filed by Mr. Williams. Sequentially, I know they're not specifically set today. In part, the responses to this motion that he received, I don't speak for Mr. Williams, but just looking at this, it appears that these aren't specifically set, but they need to be set, heard, addressed in some manner. I guess the question is the department agreeable to hearing these motions at the same time? And that is whether we even have sufficient time to hear all of the issues. I don't know, but does the department have any objections to addressing Mr. Williams' motions that bring us this motion?
I don't know when these motions were filed. Honestly, I don't have any objection to it. I'd rather the report address it than prolong it. There's been no child support payments on this case. So if he wants to be heard, I have no objection.
So Mr. Williams, you filed, what I have is a motion to dismiss the motion to enforce, the motion to stay enforcement, or motion for summary judgment. I see two motions for contempt, although they appear to me possibly might have been identical. Maybe you filed the same one twice.
They asked, I was asked by the clerk to have that physically served. So I served it once through email, and I got an email from the clerk's office saying that particular motion had to be served in person.
Who did you serve it on?
I served it on the Child Support Office, or the Department of Revenue, as well as my mother, Deborah Gill Johnston.
Okay. Well, this is the department's, this was set as department's motion to enforce. These motions that I see appear to have been in part a response to this motion to enforce the department filed. And department is agreeable by consent to go ahead and hearing these matters.
I also filed a PDPA, which is what I would like to really zone in on for this case, because that PDPA lays out the entire law when it comes to my VA benefits, which this entire case is surrounded around is my VA benefits, which I have a VA apportionment ruling as of May of 2019, which makes this child support order void ab initio.
What is, you said PDPA,
It's a Parsons due process affidavit. It's a copyrighted affidavit that has been used by many veterans across the United States to discharge their child support, because the only one who has jurisdiction over my VA benefits is an accredited judge or attorney, which neither in this courtroom are. There's already been an apportionment denial issued to Ms. Johnston and to the Department of Revenue, stating that no portion of my VA benefits are to go to any of my children. The VA has its own process to process child support payments when it comes to VA benefits. I have no other income. And as per 38 USC 511, the Secretary's decision is the finality. He has the final decision. No state court has any jurisdiction over the Secretary of the VA.
When are you, can you direct my attention to whatever you filed that you're referring to?
It's called the PDPA. I just filed it the other day. It was accepted and submitted into the docket. I have the email confirming that it was received and put on the docket, and I can give you that file number if you need it.
Give me the exhibit number.
The filing number is 220-881-658.
Well, all of these exhibits, you have them numbered, and they all have the same filing number. I have in the docket, for the record, docket entries 62 through 70. They're all exhibits. They appear to be pre-marked. Do you know which? I mean, can you tell me which?
It should be number. You said 60 what through 70? 61 through 70?
Well, I'm not sure if you're looking at the docket entries in the file. That's just a reference, but it looks like the cover on the front page of each of these exhibits. Did you write, A and then a number?
Yes. Those are just attachments that go with the PDPA. They're just to reference. I'm specifically talking about the PDPA itself, the affidavit. The due process affidavit. Yes, sir.
It's a very lengthy filing.
I probably can clear this up really quickly.
Sure.
I'm giving an opportunity to question him. He's talking about the apportionment. He's provided it, which I don't know who. I mean, I'm sure that the court could probably find that it's authentic. The VA determined that they couldn't apportion a portion of his benefits to the children. However, that doesn't absolve him of child support. Like, he still has an obligation to pay child support. So it's income.
I have.
Child support.
Your Honor, I have no other income, and this.
Sir, you can't, sir, this has to be one person at a time.
Yes, sir.
You're not gonna get interrupted, and it'll go both ways. All right, thank you.
The child support was established in 2019. Mr. Williams has made no effort to provide support for his children in spite of the fact that he's receiving disability benefits. And if the court sees fit to proceed, I would inquire from Mr. Williams regarding his assertion that the VA that somehow absolves him of paying child support.
Well, let's do this. Mr. Williams, you could answer some questions from the attorney, and we'll see where this goes. I'm certainly going to, before I make any determinations, I have to make a determination on your motions. Maybe I don't know if that will clear up some of the issues. So at this time, I'm gonna swear you in, and you could raise your right hand at this time, and I appreciate it. Thank you. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, thank you.
Mr. Williams, what's the nature of your disability?
100% totally and permanently disabled.
What is the nature of your disability? I didn't ask you the percentages. I asked you, what is the nature of your disability?
That's a violation of HIPAA. I don't have to share that information as to what my actual disability, service connection disabilities are.
What did you do? Okay, what did you do before you were disabled?
I used to be a barber.
You used to be a barber?
Yep.
When did you stop being a barber?
In 2018.
2018? You have so you haven't cut hair since 2018?
No, ma'am.
Your name AJ Williams?
No, my name is Dan Williams.
Dan Williams?
Yes.
Do you cut hair at Savage Cuts and more?
No, ma'am.
Do you recognize this Facebook
Your Honor,
page?
objection. That is hearsay.
Yeah. Do you recognize?
Objection. Hearsay.
Overruled.
Do you recognize this Facebook page?
No, ma'am.
Is this you in the picture here? Do you recognize that?
No, ma'am.
You?
Your Honor, I object to any evidence that she's showing, Facebook photos, all of that is hearsay. It is not admissible.
Exactly. When is it that you said you the last time you cut hair?
2018.
And I'm sorry, Donna. I'm going to need to inquire of the caregiver when she was able to access these Facebook. I can't see a date on here.
Well, here's the issue, is that if you're gonna present me with those photos, he doesn't have an opportunity to see them, so, even if you authenticate them, I'm not really sure how you're going to do that, because that would give him an opportunity to look at the exhibit before I can admit it.
You're running heat.
Those photos are not authenticated.
We haven't got to that part yet.
I can inquire of the mother of the caregiver as to how she received him. If he doesn't, if he's not here, that's that he requested to appear by Zoom. I don't, other other than asking her how she received them and where she received them and being able to authenticate them, I'm not sure what else. The pictures clearly depict him, and he's testifying that he hasn't worked. And, you know, so I'm not sure how the court would see fit to get them, for him to see them, but he's here online. I'm happy to stand up and show it to him and have him review it. He'll be able to see it the same way.
Your Honor, I could clarify this real quickly.
Sure, go ahead, sir.
I do supply an apprenticeship to Savage Cuts and More, which is illegal to receive revenue for. I provide an apprenticeship for all I do is I undersign another barber so that they can become licensed under the state of Alabama, which is where that is, which is where I don't even live. It is illegal to receive funds to under an apprenticeship. It's an apprenticeship. It's so somebody else can get a barber license. Because I'm a licensed barber, because I hold a license to be a barber, I'm able to apprentice another person for 2 years, in which they will be able to then take the test and get their own license. However, I do not work in that barbershop, nor do I receive any compensation or income from that barbershop. I simply apply an apprenticeship.
I'm sorry.
Good. But either way, if you have any other questions for him or for Ms. Johnston, however you want to present, please.
Sir, what's your monthly disability benefit?
I do not have to share that with you. You're not an accredited attorney with the VA. Per 38 CFR 14.629 subsection B. Only upon accreditation of the OGC and submission of a VA Form 21-22A may an attorney lawfully represent Ms. Johnston under Ms. Johnston's interest in my VA benefits without facing federal fraud charges.
I'm not pursuing his VA benefits. I'm asking for the question for his child support purposes. I'm not asking for any derivative benefit. I'm asking for him to pay to take care of his children.
According to 38. According to 38.
Sir,
sorry.
Sir, you cannot.
Whatever it is that he's quoting doesn't apply to you. The child support has already been established. This is not my attempt to pursue derivative benefits. This is my attempt to get him to pay child support. So I would say that whatever it is that he's quoting doesn't apply here.
All right. In this type of hearing, the ability to pay the child support is relevant as far as whether or not this is something that, for lack of a better word, is recoverable. If you can be paid, ordered to be paying child support when you have, you receive veterans benefits, that's another issue. But in terms of whether or not you have the ability to pay, it is relevant. So I'll overrule the objection. You would need to answer.
I do not have the ability to pay. I have no income.
You can re-ask the question if, or I don't know, that's.
Your Honor, sir, can I say something?
What expenses do you pay for?
What expenses do I pay for? I don't have to share that information with you either.
I think that is a relevance objection. I'm going to overrule the objection. But
I'm not going to ask him any more questions, Your Honor. I'm just going to ask the court grant a motion to enforce. You know, he refuses to provide information to give the court the ability to make a informed decision. I would ask the court grant a motion to court to require Mr. Williams to make a child support payment. Since he's refusing to provide relevant answers to relevant questions regarding it.
Sir, I implore
Go
you.
ahead.
I implore you to read my due process affidavit in full, because this has happened over the country in several different places, and judges and attorneys are all being sanctioned and discredited for what's going on in this courtroom right now. Do you? I don't even know if you guys even understand the law. The law is.
I haven't made a determination yet, so.
I understand, sir. But in my affidavit that I filed, it clearly lays out every single thing that she's saying, and that this order, this particular child support order, is void ab initio. The judge who signed the order was not an accredited judge by the VA to go after my VA benefits. Only an accredited judge and attorney can sign a court order against my VA benefits. And that is 38 CFR 14.629. Also, 38 USC 5301A states that my VA benefits cannot be used for child support calculations.
What is the statute you just cited?
38 USC 5301A
Okay.
and 38 USC 511 states that the Secretary's decision is the final decision, and that any questions of law may be determined by the Secretary of the VA and not by any state court.
Alright, so, is there anything else, Mr. Williams?
I mean, I
What
would.
I would anticipate, let me be more clear. So, the department's made a request on their motion, and I'll make a determination. I'll take this under advisement. I'm gonna look at the motions that you filed, and I'll make a determination. You said your motions speak for themselves and what you put in there,
Yes, sir.
and the law that you cited. So, I'm not ruling on the motion here at this hearing. I'm gonna make a ruling after the hearing. So when I say is there anything else, I just want to be clear.
Yes, there's one other thing that I'd like to state before we close out. As I have now averred, I am totally and permanently disabled, have zero income resources that can be attached for support, and formally filed documentation proving such. I now demand that my court support order and any open Title 4D enforcement case be closed pursuant to 45 CFR subsection 303.11B8. Otherwise, I will be blatantly denied both unfettered full access to my disability compensation and my protected federal civil rights from contentious adversarial system that U.S. Congress has actively legislated to preclude from such contempt.
Councilor Jackson?
Your Honor, I just want the court to understand that while VA disability benefits are protected, there's a court order that requires them to pay child support. And his testimony and his inability to provide responses to questions from the court to make a decision goes to the ability to pay, as opposed to whether or not he is required to pay child support. It will be our position that based on his lack of participation in the process, that he hasn't given the court enough information to determine whether or not he has the ability to pay. And he has failed to rebut the notion that he does not have the ability to pay. And I would ask the court grant our motion to enforce.
All right, well, as I said, I'll take it under advisement, look at Mr. Williams' motions, and this order will include a ruling on those motions, including the department's motion today.
If I can inquire, is there anything that you want the court to hear from me there? I know that you
not much I can say. It's been 7 years now. Do I expect anything now? Probably. I will raise these children until they're 18.
That sounds like she's kidnapped my children.
Alright. So I'll end the hearing, Mr. Williams. Actually, let me verify this, just to be clear. You have an email address, allenjames1323@icloud.com, is that correct?
Yes, sir.
Alright. You'll receive the, order at your email address in regards to these motions.
Okay.
Right.
I would like to state that if this case is not closed pursuant to the law, I will be escalating it to the next level.
Have a good day, Mr. Williams.
Thank you. Have a nice day.
Thank you.